Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
All right. Here we go. Let me get back to the center here. Boy, I had thought I had seen all in my time reporting from the courtroom. Claire Bronfman feigning in the courtroom, having to be carried out in a gurney. But nothing prepared me for Karen Reed and her enormous flock of lawyers crashing Aidan Kearney's hearing. They couldn't be any less inconspicuous if they were a nude marching band bursting into a church service. Karen Reed giving the side eye, devil eye, evil eye, whatever you want to call it, squinty eye to specially appointed prosecutor Hank Brennan. Alan Jackson at Aidan Kearney's hearing saying that he would be quiet. He would just go back into the gallery after being told he had no standing. Karen Reed had no standing at that hearing by the judge. And Hank Brennan says he'll go back and promised the judge he would sit back in the gallery and be as quiet as a mouse. Now, Alan Jackson's mouse-like side is something we haven't seen, but we have seen plenty of his rodent side as the Karen Reed case has gone on. All this and more today. How is everyone feeling? Let me check in. Hey, Taterbug. Hey, Tammie, Gizzy, B-Rabbit, Susan Hicks. I want to thank Julie Grant for having me on Court TV this morning. Got to talk a little bit about Karen Reed, the psychopathic accused murderer. And people often ask, like, so funny. After my appearance this morning, the great Tony Natale, my dear friend, called me and said, well, is Karen Reed going to sue you for you calling her a psychopath? I said, I don't think Karen Reed is ashamed of being a psychopath. I don't think she considers it a bad thing. Just as she wasn't offended by all the things that Michael Proctor called her. I mean, Alan Jackson and his vain clutching of pearls. Boy, did that come off. Like, oh, you're so shocked. Like Alan Jackson, the fair maiden, so offended by Michael Proctor. He's never seen such language. He's never been around the world. He isn't a fraudulent, lying, vindictive, crass defense lawyer with really no skills but conning. That's all my view of him. Doesn't make it a fact. Don't sue me, Alan Jackson. But that's how I see him and how I saw that situation with Michael Proctor. Let's get into it. First up on the docket, let's see. Oh, yeah. Karen Reed and her herd of lawyers. Let's watch them burst into Aidan Kearney's hearing. I mean, this is so symbolic of the way Karen Reed and her lawyers have approached this whole thing. Let's say, just by bullying their way in, making a scene, riling up. This was a purposeful breaking in, crashing of Aidan Kearney's hearing to rile up the Free Karen readers. Like, oh, go girl, you show that Hank Brennan who's boss. Like, she's fighting for her rights, just as the Free Karen Reed campaign is really on its last gasping breath. That's how I see it. I've seen, the irony. I don't know if it's even irony, but I'll say it's irony now, is that these Free Karen readers who are quietly dropping support from her campaign will move on to the next innocence fraud campaign, whether it's a post-conviction innocence fraud campaign or another, heaven forbid, pre-conviction Karen Reed campaign. They will move on to another innocence fraud campaign just like this, with someone just as guilty, and they'll get fooled all over again, and they will have learned nothing. We see a lot of the same figures move from campaign to campaign to campaign to campaign, crusading for justice, what they think is crusading for justice, which really they're taking part in a huge injustice, from convicted killer to convicted killer to convicted killer to convicted killer. Doesn't matter how strong the case is against them. They move from one campaign to the other, and when the campaign runs out of steam, they will move to another campaign. It's just a phenomenon that I don't fully understand. I wish I understood it better. I think that they're like the Karen readers. There are many very disturbed, personality disordered people who support Karen Reed, people who are ex-felons themselves, ex-convicts themselves, and relate and really like to see someone take it to the man, so to speak. And I think there are good people who just get caught up, and our media. I mean, look, I'm one of them. I started this podcast because I didn't want anyone else to be fooled the way I was fooled by the West Memphis 3 and Amanda Knox. I wanted some place to go where people could hear the other side of the argument and hear what these documentaries and our mainstream media is leaving out. Find me a mainstream media article that is factual about the West Memphis 3. It does not exist. You will only find the truth in small sites, fringe, what my mother would call fringe media, which is not very well respected. It's a huge problem. These media campaigns, these PR campaigns, because these innocence fraud campaigns are so rich, really take over. So they have a lot of power to just paper the walls and make you feel like, well, certainly if the West Memphis 3 were guilty, I would read it somewhere. Not so. Not so. It took me to finding a tiny podcast, small podcast, where I heard people talking about them being guilty. I just happened to come across it. And I thought, wow, this is interesting. Never mind the people that have already been so indoctrinated who would just turn it off immediately and say, well, that's not right. I know better. I've seen the documentaries. I know better. I've read Rolling Stone. I've read the New York Times. I've read New Yorker magazine, wherever else, that frequently puts out in our mainstream media that are very well respected. I don't know why, but that put out this innocence fraud stuff. So I was like, well, let me look into this a little bit more. Let me figure out what's going on. And you have to go to the court transcripts. The mainstream media is not responsible enough to give you the real facts of these cases. These post-litigation innocence fraud campaigns generally. In Karen Reed's case, it is pre-litigation, and I fear that this is going to be a pattern including the witness harassment campaign, that this will be a pattern that will be repeated over and over again. All right, here's Law and Crime. My feed went out. I was watching it on Court TV. My feed went out on the hearing. So here is Hank Brennan. Now he's trying to get from another. This is not in front of Judge Kearney. This is another judge. Karen Reed's communications from Aidan Kearney's cell phones. Communications back and forth from them. And there's been another development today. We'll get into it. This is getting extremely interesting right now with this case. Lots of stuff going on. Hank Brennan pulling no punches, showing no mercy. Karen Reed called it early. She said they're playing hardball, and they're right. We're not going to have another one of these hung juries, or that's what Hank Brennan must be saying to himself. This is my view. We're not having another hung jury. It's not going down like this. We're going to pick a great jury. We're going to show them not just what happened with Karen Reed's alleged, let's put it that way, alleged murder. They posit it was a murder. I agree. I think everyone, murder of John O'Keefe, going 24 miles an hour in reverse in her large SUV, never once hitting the brake, her foot 75% down on the gas pedal, i.e. flooring it. She hit something between 12 and 12:32. What was it? What you hit? You felt you hit something, Karen? What was it? What did you feel reverberate through your body as you were behind your rather large SUV going 24 miles an hour in reverse? So here she is. This is now just to note, I was a little slow because of I was watching it in a very, the feed's going on and off. Not sure what's happened. I've been going to court and have been confused about courtrooms or whatever. These lawyers are not confused about what courtroom to show up in. Aidan Kearney had announced that he would be sitting behind the defense table with Karen Reed that morning. They purposely staged a takeover, a courtroom takeover. That's the only way you can describe it, of Aidan Kearney's hearing. Let's watch it together.
Name. It may be, but I don't know that, and that's why I've referred.
Let me ask you this, counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove, and that they have the reports that have been generated.
Has the underlying data from the two phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it.
Hey, Lisa, we'll get to it. Don't worry. We'll get to it. We'll get to me on Court TV. Don't worry. In a very short segment. It's not a long segment. I just want to get to Linda O'Gary says, Court TV said the judge granted the prosecution the text from... So Hank Brennan won this motion with this judge. Now he's got to convince Judge Kearney that this should come into Karen Reid's case to show consciousness of guilt, which I think is a brilliant move. How frustrated were we at the first trial that the harassment campaign, that the jury would know nothing about the harassment campaign? That's the way to put it. I was frustrated. And I thought, well, it doesn't really, but it does. It shows that. And I believe that Hank Brennan in a recent motion brought in the statement that I knew that Hank Brennan had to use it. If he wasn't stupid, and he's not a stupid man, that Karen Reid made on the ID Discovery TV show. Either Jen McCabe's going down or I'm going down, or I'm going down or Jen McCabe's going down. It's her. Essentially, it's either Jen McCabe or myself. And I'm not taking any responsibility for my behavior. So I rather see an innocent woman go down. And it makes you think, what was the beef between Karen Reid and Jennifer McCabe? Curious to know. But curious to know, Linda, if that's Judge Kearney or they were talking about this judge. Because I have not heard a ruling on this. Judge Kearney has been letting in. I don't think my memory, I may be forgetting something, but my memory is that she has not rejected. She's okayed every want from the Commonwealth to bring in Karen Reid's own statements into this case. So I would think, I'm not sure how she's going to rule on phone communications. Let's see. I'd like to hear Hank Brennan's argument for how it shows consciousness of, consciousness of guilt. Did he give that argument last time? Am I not remembering it in that hearing, in the last hearing?
Or ask questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes. As Your Honor is aware, consciousness of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show, separately and in Mr. Kearney's phone, is that there was a relationship between Karen Reid and Mr. Kearney, in which Ms. Reid would provide information indirectly to Mr. Kearney. That information would then be reviewed by Mr. Kearney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is extraordinary detail on how Mr. Kearney targeted witnesses in Ms. Reid's case, with the express purpose, according to Mr. Kearney, that this trial of Ms. Reid never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle. So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt. Here's my issue. You have sought a broad swath.
Cat in the Hat. So thank you, Linda, for clarifying that this was the judge in this trial. So he won this motion despite the interruption. Spoiler alert. And just curious, Cat in the Hat. Sorry, I'm looking for your comment. How did you know Hank Brennan wasn't feeling well? Did I miss something? So Cat in the Hat says defense ambushed Hank when they knew he wasn't feeling well. Grr. How do you know he wasn't feeling well? Curious to know that. He certainly looked a little redder than usual.
Of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023. 7 months of material that ostensibly could include everything from meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do.
Okay, so here they are starting to come in. I mean, I mean, they always call Hank Brennan the mafia lawyers, but don't they look like we're going to intimidate? I mean, shouldn't this have music playing behind it? Oh, he says he has the flu. Thank you. I missed that. I've played that hearing 3 or 4 times now. There's so much to talk about. I'm going to be taking it apart bit by bit, trying to be carefully. There's a lot in it. I really want to talk about, it's not for today, but another day, talk about the way that David Yannetti snapped at Judge Kearney. I've never seen anything like that. If he did that with another judge, it would not be pretty. I don't know. The feeling is they can just walk right all over this Judge Kearney. Lazy Susan, with so many Susans around here, I'll relinquish my name. Instead, call me Mrs. Hank Brennan for clarity's sake. I think you have some competition, Lazy Susan. This is the same, Adam Lally, I will say it again, is an excellent lawyer. He is not a Hollywood performer. It's a very different. He's not made for TV lawyer. He's an excellent lawyer. Read his filings. They're excellent. However, when you have a lawyer who has both the Hollywood charisma and the excellent lawyering, it is a very powerful combination. The facts at their fingertips, they're able to argue very complicated legal points. It's something. It's such in contrast. These two legal teams, in my view, are in such contrast. You have one legal team that goes outside the law and bullies and cons. That's my view of how they work. And then you have the Commonwealth, who's playing inside the law. It's almost as if the Commonwealth is up against a team of Lance Armstrongs. That's how I see it. Anyone else? And everyone's going, well, they're in a court of law. Well, they're playing. I mean, Lance Armstrong is getting tested. He couldn't possibly be doping. Anybody else ring true with that analogy?
With communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney as an attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team, unless they have standing in this.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're watching.
Can you state your name for the record,
Of
please?
course, I'm sorry. Alan Jackson on behalf of the We didn't see which case number was called for this Rule 17, if it was Mr. Kearney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Kearney, was if this issue was going to be.
I love that. The judge is like, "Excuse me, who are you?" He's like, "Of course you know me. I'm Alan Jackson, the world famous lawyer. You don't know me? You don't know who I am? Me, the great Alan Jackson?" What ego. What ego to come into a courtroom like this. It's not just about ego. It's just the fact that he doesn't announce who he is. It really shows the ego. This isn't about ego. So let me not confuse you that this is about ego. It's about entitlement. It's about conning the public. It's about conning the courtroom. It's about creating a scene. It's about riling up the Free Karen readers to support her. That's my view of it. Punishing Hank Brennan, getting one over on him as they punish the witnesses in this case, and trying to show their power. This is a move about power and control, as is everything that Karen Reed does.
On our case number, I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 that Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights and the
It
issue.
is, counsel, counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Kearney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay.
That's correct.
Then she needed to be here, and she has a right to counsel, and we have a right. We believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that that's, yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, etc.
Those are evidentiary issues, counsel.
Correct, but we.
Which can be dealt with at a later time. Those are, what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I understand, and respectfully, I don't necessarily disagree that from an evidentiary standpoint or an admissibility standpoint, that can be dealt with at a later time. But the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s.
My understanding is that she has no right, no standing in this, and that Alan Jackson is his argument. She may have a right to be there, but she has no standing, meaning she has no. The judge was generous. Another spoiler alert, to let Elizabeth Little speak on her behalf. She had no standing, meaning she had no right to. She had no right to intervene in the way she did. She never has. You never have a right as a defendant to disrupt a courtroom. And another judge, they must have known this judge's temperament. David Unetti has been around the block in Denham courthouse. I think he knows the judge's temperaments. He knew that he could get this would fly. You do this in front of another judge, and you get thrown out on your behind. If not a sanction from the court, if not more than an admonishment, let me tell you that. Not even an admonishment here. I mean, they sort of tried to embarrass them, but this group is above being embarrassed. You can't embarrass this group. So they just don't, their feelings don't go that way.
It's dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Kearney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Kearney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half.
Right. So does anyone remember? Now I have to go back to the hearing he's talking about, but does anyone remember? So let me know if it's there. Obviously my memory, I didn't hear the mention of Hank Brennan being ill. So I listened 3 times to that hearing, obviously not closely enough. Obviously I'm still, that hearing was so dense. I said at the end of streaming it, I really have to listen to this. So much was going on in that hearing. They're getting very intense, these hearings right before trial. But did I miss it where they talked about how they plan to appear at this hearing to Judge Kearney, that they gave notice to Judge Kearney in person at that hearing? Let me know. I'm very curious if one of my eagle-eyed listeners heard it, saw it. Was there a filing I missed? Was there something I missed? What I'm trying to ask is Alan Jackson, once again, let's use Judge Kearney's euphemisms for lying, shall we? Misstating things, misrepresenting things to the court when he says that they gave notice that they would be at this hearing. It was no surprise to Aidan Kearney. He tweeted about it. Manny says, here's a free PR idea. Play audio of Mumia Abu Jamal. He's talking about killing cops, and show video of Karen Reed being very smug and shallow. I think what you're thinking of is, and I thought of it too, Manny, it was my episode with the documentarian who made a great documentary. You can watch it for free on Vimeo. It's not Venmo, Vimeo, that the barrel of a gun, about Mumia Abu Jamal and his killing of Officer Faulkner. And Mumia Abu Jamal would use this technique. It was also done by the Chicago 6. Is that correct? Is it the 5 or the 6? I'm getting confused. Is it 5 or the 6? That case where you disrupt the courtroom. So it's a technique done by revolutionaries, people who consider themselves revolutionaries, to disrupt the courtroom as much as possible to show that you're in a kangaroo court. So when you don't have the facts with you, you just scream and yell. Chicago 7, is it even? What is it? I'm gonna have to look it up. Hold on one second. Please hold. This is so it's just a technique used to disrupt the courtroom. It's Chicago 7. It's not a case I've super dug into. But yeah, you disrupt the courtroom. So one of the defendants in that had to be, they can basically, very much like Karen Reed, they made a scene so that their mouth would be taped, and the image of a black defendant's mouth and taped to a rope to a chair would startle the public and make the public think that there was some injustice going on in the courtroom, when really the judge, he had made himself so disruptive that the judge, knowing that he had a right to be there in the courtroom and didn't want to throw him out of the courtroom, that was his solution. Okay. Think the George Bush ad with revolving prison doors. Love you, RG, cat expert. Thank you. I am a cat expert. I'm shocked that no one has used me yet as a cat expert witness with my years of experience, hands-on feline experience. I feel at least as qualified as Karen Reed's expert witness, Marie Russell, in dog bites. So I'm just as qualified in feline care and felines with my years of hands-on experience being a cat owner.
And a half now. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're
And
prepared.
did you give the court notice of that?
We did to Justice Kearney,
Okay.
day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the very issues Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration, of the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the court.
He's going to be a little mouse in the room. Have we ever seen Alan Jackson be a little mouse? Have we ever seen him be a little mouse?
And once Mr. Brennan is finished, before the court makes the ultimate ruling, once Mr.
No. I would say you're more like a rat. I would say you're more like a large rodent. Alan Jackson.
Mr. Bradle is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
Judge, I have no objection procedurally if counsel wants to join in my file. That's an issue in terms of the filing. So just put it
Thank
down.
you. Thank you,
Well,
Attorney
Your
Brennan.
Honor, I do object. Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a rule.
For anyone who says that I'm too hard, I'm too biased, I'm not respectful enough of the defense team, every American should be offended by the way that this legal team is behaving in the courtroom. Every American should be offended by the fact that Judge Kearney did nothing. And it's okay to hire expert witnesses. That's what defense teams do. No one has an issue with that. It's the lying. It's the lying over and over and over. Even after you're found out, you're still submitting arguments that, these are unpaid, unbiased witnesses. No one has a problem that you're hiring expert witnesses. It would be a problem if you weren't. That's what defense teams do. But it is such an embarrassment to watch lawyers behave like this in our courtrooms in America, like con men and thieves. Disgusts me. And Judge Kearney, I'm not going to have any more lying. No more lying. I'm not going to use the euphemism she used. Candor is important. Candor is important. How about telling the truth is important in a courtroom? You're under penalty of perjury. You signed those filings under penalty of perjury. Right? Is it penalty of perjury? Am I correct about that? I'm second guessing myself. Am I right? Right? They sign their good name. They say every time they sign a document, they're saying we're being honest with the court. I don't know if the penalty is perjury. I think it's more like sanctions now that I'm thinking about it. But that's what it means. I'm being honest with the court. And they're like, sorry, we weren't honest. We did pay them. We paid them $23,925. That's the discovery we've gotten. It's the only discovery Hank Brennan said he got in this case from the defense. Now, have they, since that was a couple hearings ago, have they changed their act? Doesn't sound like it. We're still talking about doing these pointless voir dires as sanctions for them not handing over discovery in this case. All right. Well, I think this is where we can leave it. But Hank Brennan won his motion. Oh, actually, you know what? Let me see if I can
Rule
play
17
this.
motion of third party.
Let me see if I can play this just going a little bit faster. I just want you to see how this, like, see if this is too fast. This may be too fast.
She has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at council table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her
Thank you.
considerations there
We
too.
appreciate the court accommodations.
Look at Bettero smiling. Hello, murderess, accused murderess. Hello. Now, of course, Judge Kearney rejected Karen Reed's request to have him as part of her counsel. It's almost like she is trying to make issues so that she will have appealable points when she gets convicted. Not saying that that's right, but you cannot have her interests and Turtle Boy's interests. And I believe Bettero did help out Karen Reed. I don't know if he's still helping out Karen Reed with her case. I don't know to what degree, but as you know, believe he said he's helped her out. I don't know what that means. But to have him come on officially as her on the legal as a lawyer would be such a conflict of interest since he's representing Turtle Boy in his witness harassment case.
So, ADA Brennan, with the court's apologies for the interruptions.
Why is the judge apologizing and not any of these lawyers? Did you notice no apology?
Of the issue, as I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant, involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and I've identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to obtain this warrant, which is a far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at section D, there was probable cause granted for communications between Mr. Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled because we'll clearly have met our burden of proof, not only because of Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we provided. There is.
Hey, Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel from Ms. Reed?
No, I think those would be privileged. Secondly, there are motions filed in this case, not Karen.
So I started saying Kearney, and then I got corrected that it's Kearney. Now I hear people say Kearney again. I've heard that Aidan Kearney. I don't know. I don't know. Says his name like that. I'm not sure. Does anybody know why there's so much confusion around the actual pronunciation of his name?
Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the two phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth versus Kearney case, docket number 53, Commonwealth revised proposal for examination.
So, spoiler alert, Hank Brennan also wants to put Karen Reed's lawyers on the stand. Now, people are saying this is just to verify. They may stipulate her conversations with Gretchen Voss. Not sure how it works legally here. I'm not a lawyer. But I would think from Judge Cannoni's footnote in one of her decisions, where she talks about a meeting with, it's a July 2023 meeting with Gretchen Voss before she wrote her piece in Boston Magazine, where Alan Jackson is giving her information he says that he shouldn't give her. That's private legal information, and telling her not to write it until after it's published. I'm curious to see if any of wanting them on the witness stand is about their communications with Gretchen Voss or other of the many interviews they seem to have. Alan Jackson much more than Yannetti. It's mostly Alan Jackson. When you see Karen Reed interviewed, it's mostly you see her with Alan Jackson and not David Yannetti by her side. So I'm curious to see if this is about the release, answering questions about that. I'm as a strategy as part of this witness harassment campaign. If the witness harassment campaign's coming in, certainly that would be part of it. To use the courts to get information out, to rile up the public. And they used Aidan Kearney as sources in their own motions, meaning they would write, it's been reported as, on things that I believe they made up. Little bit of truth mixed with a lot of lies. Just mixing it all up. That's Karen Reed's style.
Of digital material seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an air broadcast on a documentary last night, the night before. There are admissions that she was, in fact.
Okay, so spoiler alert, and I'll get to your comment, B. Tim, in a second. Spoiler alert. Basically, the essence of all of Karen Reed's lawyers when it comes to Aidan Kearney is our client shouldn't be punished for Aidan Kearney harassing witnesses. Basically, they're just saying, she has nothing to do with it, Your Honor. She's an innocent little lamb, didn't know anything about. She didn't tell Aidan Kearney to go up to Jennifer McCabe at one of her children's sports matches and say, you thought you could outsmart Karen Reed? She didn't do that. Pure as the white driven snow is our client, Karen Reed. P. Tim, I think this docu-series is hurting Karen more than helping. I'm seeing way more people not liking her this time around than before. Yeah, it's all falling down, B. Tim, right. It's collapsing. It collapsed with this is why Karen Reed's own lawyers are still arguing in court. They want to bring in the federal investigation. Why would they want to bring in the federal investigation? Because they want to show the jury that these ARCA witnesses are unbiased witnesses. LOL. These witnesses that were paid $23,925, that's the payment we know about. There may be more discovery that the defense is hiding. These are the witnesses that they helped craft their testimony, the defense, but they were totally independent and unbiased because they were hired originally by the feds. But we don't know why that federal investigation was started, except that we know that it was started by Karen Reed and David Yannetti. But why the Attorney General's office took it up, we don't know. Anna Shaw, thanks for the super sticker. Thanks, B. Tim. Thanks all for supporting this channel. I'm going to take a quick break. When we get back, my appearance on Core TV this morning on opening statements with Julie Grant. Don't go anywhere.
Roberta in the truth zone, mic hitting raw. Spotlight shining, she exposing the flaw. Debunking the myth, breaking their facade. This is Glass City, respect the squad. On these NYC blocks where the skyline flex big. Roberta Glass slicing lies with a truth rig. Innocence frosters, your stories unravel. She's a map through the madness of gritty gravel. Glass don't bend and facts don't break. She's a storm that's called, you feel the quake. Exposing tales stitched with crooked seams. Justice in the lens, shattered fake dreams. Screams about killers, painted heroes in disguise. She burning propaganda with fire in her eyes. No glamour for the guilty, she call it straight. She backs victims, the voice stay awake. Stats and receipts, no spin, no clutter. Cold cases whisper, she cuts through the mutter. Truth's her tempo, don't confuse the beat. She's standing for the real while you taking a seat. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time to play. She's glass hard, break the false and save the day. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time to...
Okay, let's get into it. It's been too long. It's a very short segment. Here you go.
This morning, we're giving a voice to victims like Boston police officer John O'Keefe, the 16-year veteran that prosecutors say was murdered by his girlfriend, Karen Reed, inside of the Massachusetts courtroom where the case will be tried again. On Thursday, you could cut the tension with a knife. And did you get a load of this moment? Karen Reed and her attorneys seemingly ambushing Special Prosecutor Hank Brennan as he was in a separate hearing with defendant Aidan Kearney. He goes by the name Turtle Boy. Now, this is all over the special prosecutor in Karen Reed's case obtaining the contents of the cell phone searches done by the prosecution team on Kearney's case. Let's take a look.
Text, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney's attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team unless they...
Do you guys see the hair flick and the look? Wasn't there a hair flick there? Did I miss it, or does it come later? And there, we got the squint, we got the look. I mean, they think that they're... I mean, it's really like watching a bunch of gangsters. I thought of the Patty Hearst video, where she's robbing a bank. I was like, is she going to change her name to Tanya after this?
Yeah, standing in this.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're...
Counsel, can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of Ms. Reed. We didn't see which case number was called for this Rule 17, if it was Mr.
Excuse me, mass lawyer. Who are you? Oh, you don't know me? I can't get over that moment. I can't get over it.
Kearney's case number, or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Canoni, was if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said yes. She needed to be here, and she has a right to counsel, and we have a right. We believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
No, it doesn't stop there. So why are Karen Reed's attorneys on the witness list?
No. Oh no. Is my computer freezing? Hold tight, guys. Hold tight.
For the Commonwealth. We have so many issues to get to here. We're going to do our best to hit them all. I am so pleased to welcome in on the program podcaster Roberta Glass. She's the host of the show True Crime Report. She's joining us this morning along with David Bruno. Good morning to you both. Okay, let's start with that relationship, the relationship between Karen Reed and Turtle Boy, and that very brazen, bold, and dare I say it, rude interruption of the hearing right in the middle of it, and that dirty look Karen Reed gave Hank Brennan. Roberta, let me start with you. Your reaction to that?
Well, it's typical of what we've seen from Karen Reed in the courtroom. Very inappropriate, very angry at Hank Brennan. That's the Karen Reed we've come to know, a very angry, vindictive, I would say psychopathic woman.
Roberta, thank you for that. You know, she does look angry. I mean, and she knows, she's cognizant about it. She knows cameras are rolling. We heard her talking about it in the investigation.
Okay, I'll give you a little behind the scenes. So I thought we were talking about them coming into the courtroom. So she threw me a little bit with that question about the look. I was expecting, what did you think of them coming in, bursting through the courtroom doors? I was like, what about the look? The look? You want me to talk about the look? So, you know, you do these on the fly very early in the morning. Kitty says, yay, Roberta, congrats on your appearance. Thank you. So that's just a little inside baseball. I was really thinking Julie was going to ask me, like, hey, what did you think of her lawyers basically holding the courtroom hostage? But that wasn't the first question.
Investigation Discovery docuseries. You know, to me, this is her trying to deliberately make a moment, and I think she made a fool of herself. That is incredibly disrespectful behavior. It has no place in a courtroom. Hank Brennan's doing his job. And let's not forget, Hank Brennan's a defense attorney. He's one of the best criminal defense attorneys in the country. That is his reputation. And a long time ago, he was a prosecutor. He's earned his reputation. He's also a trial advocacy professor. Not the guy I'd want to mess with. And I'm sure he's been through way worse than Karen Reed's dirty looks. David Bruno, you just always...
So it's just, you know, curious to think how Hank Brennan is taking this. This is someone who teaches law, who's dedicated his whole life to law, and then he's watching these gangsters come in and basically dirty players, in my view. It must be so, and to see the judge essentially condoning it. She put down her foot with her words, but then did nothing when they misstated things. We'll see if there's any pushback on that from Alan Jackson, saying, no one directs my client to say anything. You know, Karen Reed doesn't direct Turtle Boy to say anything. Oh, except to Jennifer McCabe, of course, to go up to Jen McCabe and say, you thought you could outsmart Karen Reed? I mean, that's direct direction. No one thought, you know, you'll see my answer, you know, but nobody thought that Aidan Kearney was Karen Reed's spokesperson. You know, that's certainly not the role. I thought, very clever use of words when Hank Brennan described it as a symbiotic relationship between Karen Reed and Aidan Turtle Boy Kearney. It's a good word for it. I don't believe that Turtle Boy is fooled. I don't believe that he believes in her innocence. I think he now has a PhD in innocence fraud. He gets it. He loves it. He loves the money. These innocence fraud campaigns are big money, fast money.
epitomize, respect. You're the quintessential gentleman and know how one should conduct themselves in the courtroom. If your client did that, what would you say to them?
Yeah, here's a message to all litigants. I don't care what case it is. You're always being watched. You're being watched by the public. You're being watched by the jury if they're seated, the judge. There's always observations going on. Look, we even talked about it in the Koberger case just a couple segments ago.
Hey, Jude says, Roberta, we all appreciate you so much for sticking by the straight and narrow. Well, what do you know? There is life on this planet. Oh, that's sweet. Hey, Jude. Nice to see you. I think someone was asking where you were the other day. Hey, Jude. They're like, have you seen Hey, Jude? She okay? Glad to see you're okay. You're still out there. Thank you.
About how they're concerned, about how the jury sees Koberger and his flat effect. So for anybody there, you have to conduct yourselves knowing that you are being observed. And she should know this. She should know this. I don't know if it was deliberate. I believe she's a little out of control right there. And you see that little squint at the end, too. It's like almost like piercing stare. And the reason is, guys, because the prosecutor wants to get into those communications with Turtle Boy. He believes that those communications will show consciousness of guilt. And she's almost like, well, how dare you?
So my boyfriend actually had the best reaction to this. He goes, why is Karen Reed coming in the courtroom? She says there's no relationship, not no relationship, that, that there's basically nothing to see on these phones. She's not instructing anyone. She was no part in this witness harassment campaign. Turtle Boy did it all on his own. Meanwhile, she's saying to the ID Discovery TV crew that she talks to him every day and releases him material, but only material that's public, guys. Don't get it twisted that she would, like Alan Jackson did, release sealed evidence to him before it can come out in a filing. Don't get it twisted. Never Karen Reed would do that. Tammie, Roberta, you look gorge. Necklace, rocks, glasses are you. And yes, interview on Court TV is wonderful. You're much better than them. It's fact. Thank you. Certainly, certainly I've had my, my certainly broken down a lot of Court TV material on this channel. And I think that, there really needs to be, I don't know, I'm thinking about doing some longer, like more of a long form interviews about true crime, because these cases are complicated. It's really hard to fit in what you want to say in very small sound bites.
Right? One more sort of pull of the thread that the state is trying to do on Miss Reed.
Yeah, thank you for that, David. Great points. This relationship between them, Roberta, they hid it for so long and acted like, he's just independently, talking about this case. And then here it's like, Hank Brennan's exposed it all. Roberta, you've covered it from the beginning. How do you feel at this point in time? Do you feel like the House of Cards has been brought down?
Oh, I feel like her legal team is definitely, the momentum is with the Commonwealth now. But I mean, they can lie. She can lie. Her legal team can lie to the court, in my opinion, about her relationship with Aidan Kearney. Alan Jackson using very deliberate language that nobody speaks for Karen Reed. Nobody thought that Aidan Kearney spoke for Karen Reed. However, there are 29 communications between Alan Jackson and Aidan Turtle Boy Kearney, and 29 communications between David Unetti. Okay, Alan Jackson.
This is when they found her phone. So the time period so when they found her two phones that she communicated with, there were 29 communications. 9 of them were by Unetti during the time period I say, and it was rushing. So I kind of slip up here. And 3 between Alan Jackson. So they were communicating. My point was that they were communicating with Aidan Kearney multiple times during the period. They have a relationship with Aidan Kearney. They communicated with him multiple times during the period where this witness harassment was going on. And I go further to say that they never publicly called it out, said, please stop this witness harassment, which they had the power to do. They certainly had many, many appearances on the courthouse steps, pleading her innocence, appearances, time, media appearances to say, please stop harassing witnesses. And never once did her or her lawyer say, stop harassing witnesses. That's very telling. It's very telling in a hearing that Karen Read, if there's nothing incriminating that shows consciousness of guilt on her phone to Aidan Kearney, why disrupt it this way? Why disrupt it? Oh, get those messages. You're not going to show anything. Get them. What if he wants to hear me talk about my tuna salad recipe? Go ahead. He can have it. Maybe he'll enjoy it. Hank Brennan. That's what an innocent person would say. Lackadaisical. Funny how LawTube is still silent today after Hank's motions today. Yeah, it's getting good. I have so many shows coming up. I will go through. I hope everything. I can only cut off so much and chew in one episode, but there's a lot going on in this case, and hopefully we'll cover it all. I just don't think it's going to all be covered tonight. Lackadaisical, thank you for your support. I appreciate it. Yeah, it's getting really good. Lackadaisical, isn't it? Isn't it getting good? Showing no mercy, Hank Brennan.
And David Unetti about 29 times between April 20th and May 2nd, 2023. That's the time when the most witness harassment was going on. You notice that they never publicly said, we love the support that Karen Read's getting, but call off the dogs, please don't harass witnesses, please don't boo the victim's family. They never said that publicly because it was part of their strategy. So it's not just Karen Read, it's Karen Read and her legal team that are behind, in my opinion, behind this witness harassment campaign, because they can't use the facts. The facts aren't with her.
Roberta, great points. Thank you. So we know that Hank Brennan is trying to get these messages in to his case because he says that it would show Karen Read's consciousness of guilt, saying that she would have no reason to employ Turtle Boy to allegedly harass these people if she hadn't done this. Now, we know that she says she's innocent. She's claiming that she's being victimized, claiming that I believe it's a 50-person conspiracy cover-up.
Julie Grant, I know that Karen Read is saying that this is a 50-person cover-up. I know that she's saying that it's an enormous cover-up of many, many people, all because they want to frame the financier, the adjunct finance professor. Why, we don't know. I know she's saying that. You kind of laugh. Lackadaisical, thank you for your gifting 5 memberships to my channel. They will be distributed at random. That's funny, right?
Alleging and all this, she's saying she's innocent of the crime she's been charged with. Something that may give us insight into what was going on in those final few moments before John O'Keefe was taken from this earth. His own statements. I've got a clip here about it in the state of the relationship between him and Ms. Read. Let's take a look.
We know from the statements that there was a tumult in that relationship, and many of those statements are reduced to writing. And it is clear, based on that and other testimony, that he was in the course of attempting to end the relationship with Miss Read.
That's preposterous. The idea there.
By the way, let me just say something. Since this wasn't a conversation, these are not natural conversations that you're having on Court TV. And since I have a little bit of time tonight, with when my fellow guest says, who is a lawyer, says, you have to watch how you act in court. Karen Read is very well aware of the camera. She's very well aware of how she appears on camera. Remember when she had that feral moment with Alan Jackson in her first trial? It was like, it almost looked like she was going to bite him. Like she bared her teeth at him and was like whispering, stage whispering at him in this really aggressive manner. And then when the jury came in, she sort of pulled herself together. She's very aware of the cameras. She's very aware of the jury looking at her. There's a whole section in the ID Discovery show where she's talking about how she looks this way, they're going to be that way, and they're going to think if she doesn't cry, they're going to think she's cold. But if she cries, then they're going to think she's putting on theatrics. She can't win. I think Alan Jackson makes that argument. And Alan Jackson, I believe, tells her to just be herself, which is a terrible advice to Karen Read, to just be herself, but okay. So she's very aware of the cameras. She didn't do this because she was late. This was, in my view, a meditated ambush of the court that she did, that we're talking about. So, very good advice to be aware of how you look as a defendant, but that isn't really applicable here, I would argue. She's aware, and I think Julie Grant, you heard her make the same argument. This is absolutely done on purpose.
There is no evidence to support that last point, that this type of information, let's say, for instance, it's information that he wanted to break up with her. There's no suggestion in the facts that Karen Read would kill John O'Keefe rather than simply break up with him.
Okay, so we'll have to see if these statements from John O'Keefe make their way into the case evidence. The judge still hasn't ruled on that.
Let me reflect. Thank you so much. So glad I found your channel. You were one of my heroes. I appreciate your work. Thanks for being so brave. You're welcome. Let me reflect.
David, something that people are getting a lot of questions going about on.
And thank you for your support. I really appreciate everyone being so generous tonight. Appreciate it. You're keeping the channel going.
Social media, because it is odd to see. The Commonwealth has put 3 of Karen Read's attorneys on the witness list, reportedly so that they could authenticate the out-of-court statements that she's made to various media outlets. How do you see this playing out, please?
Yeah, I don't actually see it playing out. It would be very odd to see her attorneys in the witness stand at her trial. I don't think it's good optics for the court. Look, there could always be a stipulation too. If it's to authenticate an out-of-court statement, certainly a stipulation would be enough. And then just final point on this whole Turtle Boy angle that Brennan and the government's looking at. This has already been a circus. The first trial, circus. All the crowds, all the followings and things. If I were prosecuting this, I would want to go in straight. I don't know if I'd want to add this whole Turtle Boy angle of consciousness of guilt because of out-of-court statements and communications. I just question it because of all of the different distractions that we've already seen in the trial.
Mm-hmm. Yeah, fair point. David, thank you for that. This is a mess.
Forensic RN, thank you so much for the super sticker. I appreciate it. So just to give you some inside baseball, they tell you to express your point in a few sentences. It's really hard to do. It certainly was a challenge for me. And right before I'm given the final point, I have someone in my ear going, one sentence, I think. One sentence, 15 seconds, something like that. Like really quick, keep it really brief because we were running out of time for this segment. So this is the end of the segment. But certainly, it made me appreciate that my own podcast where I could talk endlessly, go into detail, explore points. And I think they're, the time frame of these really, short sound bites. I also, I have so much to say about
Of a case, it has become a circus. And Roberta, I want to give you
enough of me talking. Let's just show the clip. That's how I feel.
the final word here. As we get ready to go to trial, of course, with any case, we know Karen Read has pleaded not guilty. She's cloaked in the presumption of innocence. It's up to the Commonwealth of Massachusetts, as you know, to prove her guilty beyond a reasonable doubt. With all of these things coming out in hearings like yesterday's, where we know they're going to use the temperature of John O'Keefe's phone, the text stream data to show exactly where her car was at the time and place, do you think there's any way we would see a plea agreement here?
Never. She'll never plea out. She will be blaming other people for what I feel is her murder of John O'Keefe till she dies.
Roberta Glass, we have so many more things we need to talk with you about. Check out Roberta's podcast, True Crime Report. It is awesome. I'll look forward to having you back soon. Thank you so very much. And David Bruno's coming with us. And
Okay, that's it, guys. That's it. Jackie Joe, thank you for the $5. Let us get into, should we take a break or should we just get right into it? Maybe we should just get right into it. How long have we been going? 116. Let's get into this filing. Innocence Fraud Watch, the great Innocence Fraud Watch. If you're not subscribed to her blog, you are missing out. She knows everything about this case. Blogs are excellent. Link is in the description of this episode. Subscribe. So what I like about subscribing is you get her posts, her blogs in your mailbox. You don't miss one. And so when she puts up new filings from this case, you get it. When she puts up a new blog, you get it. And you get her incredible timeline on this case. This timeline is such a gem. The work she's put into it, the detail. Check it out. So I wanted to show her Commonwealth motion to compel communications between the defendant and attorney Yannetti stored within the defendant's cell phone data copy. The Commonwealth motion to compel communications between the defendant and attorney Yannetti. So I was like, what is going on? So this is, when I first saw this, I was very confused because, as you know, attorney-client communications are privileged. But here, Hank Brennan's going to argue Karen Read gave up her privilege, spoiler alert, when she talked to the ID Discovery TV show and made some remarks. Let's get into it. So the Commonwealth seeks all texts, emails, or written communications between the defendant, Karen Read, and attorney David Yannetti, restricted to those communications that occurred between January 29th. So really this crime occurred on January, at between 12:30 and 12:32, January 29th, a.m., early morning hours. But everything leading up to it happened on the 28th. And February 2nd. So this is the time that Karen Read says she was curled up. Maybe one more day, maybe it goes into the 3rd February, where she says she was curled up on her couch, on her parents' couch, Denton, because she was so bereaved over the loss of John O'Keefe. But she was actually out. I think it was on the 30th. I'd have to check the timeline. It was like the next day, I believe, the next day or the day after, February 1st or the 30th. My memory is the 30th, but I could be wrong. Out with a private investigator retracing her steps, looking for clues as to what happened that night, as if she didn't remember. The thing about this ID Discovery TV show is that it makes me more secure with my opinion that drinking only loosened Karen Read's, if she had any inhibitions at all, I'm not sure if it did to what degree I'm saying it loosened her inhibitions to commit this crime. But as far as a real factor in this crime, I've never felt that it was a real factor. It's only secured me in that opinion, and the opinion that you're going down the wrong road when you're looking at jealousy with Karen Read. I feel that she did these jealous tantrums and these accusations. I hate you. You're a pervert. These kind of things to gain power and control over John O'Keefe, to put him on the defensive. I don't believe that she was sincerely jealous in that way. Believe this was a means of control. So when Karen Read comes out and she says, well, when I'm drinking, I don't remember, but I remember everything, but I don't remember, but I remember, but I don't remember, makes me think I'm right. She remembers everything. She did not forget. And for those of you that say, well, this was an accident, why is the Commonwealth charging her with a second-degree charge? Let's look at one thing that's not talked about very often, which is that Karen Read, and only Karen Read, knew that something terrible had happened to John O'Keefe that night. So if you have a fight with your boyfriend and you drop him off at a party and he doesn't come home and it's a nor'easter, he doesn't have a car, right? You drop him off there, he doesn't have a car, and it's a nor'easter. Huge, massive snowstorm. Wouldn't you think he's sleeping at a friend's house? He slept over at that house, somewhere. You wouldn't run into a panic at 5:30 in the morning and start to say he's dead, and dead in a really bizarre way, hit by a plow. He got hit by a plow. That's what you would assume. And only Karen Read knew right where to find John O'Keefe, on the dark side of the front lawn of the Alberts house. There's a really important details in this case. If you had drunk too much, forgotten, not known, you wouldn't be calling up people and saying he's dead, and then saying I hit him to people. You wouldn't know what happened. This is why it was so important for Karen Read. I think the people that are saying it's an accident are buying into Karen Read's lies. I said, did I hit him? I was confused. Karen Read's not confused. She knew exactly what happened. She knew exactly what she did. And I don't believe alcohol really, touches the sides with her. If anything, it might loosen her inhibitions slightly. But, if the rumors are true that Karen Read held a knife to her ex-boyfriend's throat, if the rumors are true that she lit another ex-boyfriend's car on fire, we won't know because none of her ex-boyfriends are speaking, then this is all in a pattern of behavior for Karen Read. Not unusual. And I think Karen Read's own words about this crime are really salient, which is, it's a mistake to think that this crime wasn't planned. The point was, the aim was to teach John a lesson. At minimum, those are my words, paraphrasing her words. It's not exact. The aim was to teach him a lesson at the minimum. I think that's really important. I think that's really telling. Now, of course, she was talking about the conspiracy. But I think it gave her away. I think that's a confession, frankly. I think she'd been fantasizing about this. Your boyfriend doesn't wear a jacket, don't you think? You just hope he doesn't get incapacitated one day and get stuck in the cold, freeze to death, or something else terrible happened to him in the cold. John O'Keefe never wore a jacket. She couldn't have missed that from 2 years being with him. The privilege holder, Karen Read, has waived her attorney-client privilege with Attorney Yannetti relative to any statements about her collision with John O'Keefe during the time of January 29th through February 2nd, 2022, the defendant voluntarily and intentionally disclosed the existence of these communications and her initial thoughts about her culpability for causing the death of John O'Keefe during various public interviews. And in person to a search warrant, the Commonwealth received the contents of the defendant's cell phone. Because of observed attorney-client communication, the phone data was provided with the assent of the defense to the Attorney General's office, and a court-ordered taint team protocol was implemented. So these are these taint teams. So it's like not the defense, not the Commonwealth, looks through the phone, someone with no involvement in the case looks at the phone. That's the taint team. The Commonwealth received the defendant's phone data with any privileged communications excised, meaning removed, given the defendant's public waiver of the attorney-client privilege as it pertains to the defendant's conversation with Attorney Yannetti on January 29, 2022, and the following 3 days, the Commonwealth is entitled to the communications between. So basically, she messed up big time talking about this on the Discovery ID documentary. I wouldn't call it a documentary. I would call it a TV show. Between the defendant and the Attorney Yannetti for this waived narrow period of time. I mean, it wasn't really documenting. It was anything but Karen Reed's point of view. During various public interviews, the communications confirmed by the defendant to exist are no longer privileged, nor confidential, because the defendant chose to widely and publicly disseminate them. In support of this motion, the Commonwealth acknowledges and respects that the attorney-client privilege protects privileged communications between a client and his or her attorney. Waiver of those principles, okay? If you're a guardian or an administrator, I'm just going to kind of skip through this. Conduct constituting waiver, except as provided in Section 524. Privilege matter disclosed erroneously or without opportunity to claim privilege. A privilege is waived if the person upon who this article confirms a privilege against disclosure voluntarily discloses or consents to disclosure of any significant part of the privileged material. So she voluntarily talked about what she told David Yannetti that morning. Okay, so let me skip forward. In this case, to ensure that the only communications that were waived are provided, the Commonwealth requests that this honorable court review in camera, meaning in secret, all text messages and written communications stored in the defendant's phone data for the time between January 29th and February 2nd, 2022. In this case, the privilege holder, the defendant, has clearly and intentionally waived her attorney-client privilege regarding specific conversation she had with Attorney Yannetti regarding the collision between her vehicle and John O'Keefe. For example, in the defendant's recorded interview with Gretchen Voss on January 20th, 2023, the defendant concedes, "You never said, did I hit him? I hit him." Answer, "I said, could I? Did I? Could I? Did I hit him? And then, when I talked to David," now this is later, this is Karen Reed talking in the ID Discovery TV show. "And then, when I talked to David," now this is later, "David said, Karen, if you incapacitated him in any way, there is culpability there. And I thought, all right, maybe this is maybe I said to my mother, just to go forward a second, they were asking me, what was it like? Did they come out? What was the house like?" Attorney Yannetti, Jackson, and Little were in attendance along with the defendant and Ms. Voss. Here's again, another, and no one stopped her from saying, "No, whoa. You're not going to tell Gretchen Voss what you said to me that morning." could waive your right to communications. So don't tell me what great lawyers David Yannetti and Alan Jackson are. Great lawyer would go, whoa, 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 whoa. Even a good lawyer would do that. Second, in a Vanity Fair article entitled Karen Reed Tells Her Story, Part 1, a murder trial in Massachusetts with a caption, as Karen Reed's second murder trial looms, she's ready to talk about what she says really happens. Published on October 29, 2024, the defendant, who according to the publications was notably aware that anything she said could be used against her, volunteered a rumor that alleged representations made by... Hold on. I just lost my place. I just blinked and lost my place. That's what happened. My apologies. Here we go. She said that... Okay, here we go. Who, according to the publication, was notably aware that anything she said could be used against her, volunteered a rumor that alleged representations made by the Massachusetts State Police that there is text messages between her and counsel that implicate herself as a provable lie. Wow. Third, in the now airing 5-part docuseries, I wouldn't call it a docuseries, but okay, that's what they probably call it, on ID Discovery and HBO Max, entitled A Body in the Snow, disgustingly titled, A Body in the Snow, John O'Keefe in the snow after being hit by Karen Reed, the Karen Reed story. I don't know what you call it. I mean, it's anything but that. The defendant professes, and then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over? Or what if I clipped him in his knee and he passed out? Notice she didn't say, what if I clipped him and he hit his head and spun around? Or what if I clipped him and he spun around and hit his head on the hard ground or the side of the curb? What if, David? Yeah, what if? And he passed out or went for care himself and threw up or passed out. And David said, yeah, then you have some element of culpability. So that's how I thought about things for about 3 days. 3 days. 3 is the liar's number, by the way. Do people know that? It's a number that liars often use. She says in the beginning of the episode, what if I'm blinking 3 times and looking up to the left, meaning she's lying? She was worried about looking like she was lying in the beginning of the TV series. The privilege holder is the defendant, and the defendant intentionally waived her privilege by disclosing her conversations to a nationwide audience with her attorney. The attorney-client privilege can be waived only by the client. In addition to rendering the communications non-privileged, the communications are relevant as admissions and statement of the defendants. These statements are admissible substantively. And Attorney Yannetti's statement to the defendant are admissible. Whoa. So is that why he's asked? He's gonna. So now that she's waived it for both of them, sounds like. Wow. So this must be what he wants her up on the. I must be wrong about Gretchen Voss. This is why he wants David Yannetti up on the witness stand, I would think. Also, the defendant's admissions and Attorney Yannetti's statements are relevant to challenge the defense later. I mean, I don't know what he wants Alan Jackson up on the stand about, but I haven't caught up with all the filings. If there's something in there. Wow, this is what he's asking about. Purports claims of third-party culpability. The communications have relevance to rebut the defense's potential claims that some other person committed the crimes that caused the death of John O'Keefe. Moreover, the defense has suggested that as part of this defense, it's likely to pursue a Bowden-type defense. The potential evidence is relevant to rebut claims of law enforcement contrivance. So they're going to say that law enforcement planted this evidence. It was so bad. It was such a bad investigation that it made it look like Karen Read did it. Wow. Wow, wow, wow. That's where I'm going to end it for today, guys. Thanks so much for hanging out with me. Jackie Joe, did I thank you? I hope so. Forensic RN, I believe I did, but thank you guys for your support. I will be back. So listen, guys, I am traveling this weekend for a family thing. I hope to make a show tomorrow. It may be impossible. It certainly will be challenging. Lackadaisical methinks the defense attorneys will be busy this weekend. I think so too. Good call, Lackadaisical. Absolutely. Thank you. So I will try my hardest to get on a show tomorrow. It may come a little late in the night. It may be later. It may be earlier. It may be not at all. But I will try my hardest. But it certainly is difficult when I have family obligations and I'm traveling. So I will try. And otherwise, I will see you Sunday, always at 6 p.m. Eastern. I'm here 5 nights a week. Have a great night, everybody. Thanks for listening.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my